There we go. Now let's just see if we're live streamed. YouTube. There we go. It says we're live streaming, so let's get going. Okay, so I'm just going to read the intro, Dean, and then we're going to get into all of that good stuff.
Okay.
So welcome to Tea Time, guys. Miss Liz here. We had a couple of little glitches, but we're back, and I want to thank everybody for tuning in. For everybody that was joined on StreamYard. StreamYard sometimes it just does that. It gives us some issues. So we're going to do a little bit of welcoming into Dean, and then we're going to get into the topic, and we're going to serve a good, strong cup of tea. And again, tonight's tea is expert in psychology and law. We'll be talking about that as well. That's the tea we're serving. Welcome to Tea Time with Miss Liz, where we create a safe space for conversations that sometimes are difficult, often emotional, but always important. Today's conversation addresses topics that affect children, parents, families, and the legal system. It requires honesty, compassion, and a commitment to keeping the well-being of children at the center of every discussion. Please join me in welcoming Dean Tong, author, forensic trial consultant, expert witness, and international recognized advocate whose work has focused on child abuse, investigations, high conflict custody disputes, and the importance of evidence-based practices within the family court systems. Dean is the author of Abuse Excuse, a book that explores the complex issues surrounding false allegations in court disputes, the impact they have on children and families, and the importance of pursuing truth while protecting those who are generally at risk. With decades of experience working alongside attorneys, mental health professionals, and courts, Dean's mission is to encourage careful investigation, fairness, and the decision that prioritizes the best interests and safety of children. Today's Tea Time will explore protecting children's well-being, the importance of evidence and due process, high conflict custody challenges, family court and child advocacy, and seeking truth while supporting families. This conversation recognizes an important reality. Every allegation of abuse deserves to be taken seriously and investigated carefully. At the same time, decision affecting children should be grounded in throughout evidence, fairness, and their long-term well-being. So grab your cup and join us for a respectful and thoughtful conversation filled with awareness, compassion, and real-life tea. Truth, experience, and awareness. And let's get Dean's to share a little bit about all of his incredible work that he does and his strong tea and expert in psychology and law. So welcome, Dean, to the show.
Thanks for having me this evening, Liz. Appreciate it.
Well, thank you for putting up with all the technical issues and keep popping back and forth. I like to try and get it in, bam, 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 and I like to get the important topics out there. So, Dean, let's talk a little bit about who Dean was and how you got into this field that you're working today.
Yeah, well, that's no mystery. I had a first-hand experience, was accused myself of molesting my 3-year-old daughter back over 40 years ago in 85. Vindicated, but the trauma of the ordeal brought me from criminal court, which I won my case, to family court, where the judge erred on the side of caution, basically hampering me with supervised chaperone monitor visitation. One of the longest stints in Florida history. I had to see my kids chaperone for over 4 years. Finally got unsupervised parenting time, but not overnights, because the judge basically gleaned where there was smoke, there was fire. He didn't care that I won the criminal case because the evidence drops from 95% to 51%, where a judge can use his discretion to basically make a mistake on the side of the child. And of course, I had 2 children, and that's what happened. So I decided that with this issue, Liz, there was a dearth of law, a dearth of psychology, a dearth of social science. The left hand didn't know what the right one was doing. A lot of well-meaning, well-intentioned people were misguided. They were missing real child abuse on one end of the street while creating a witch hunt or a source misattribution error on the other side of the street. So I decided to take this into my own hands personally I wrote several books. I ran for Florida politics in 1994, spoke around the country on this issue, including Washington, D.C. several times, Tallahassee, my state capital, and then went on to get a master's degree, basically distance learning program through the United Kingdom upon Dr. Stephen Cece's recommendation. And then it's just been tackling one case at a time for the last 25 years, since 2001. I'm an old man now, but there aren't many people that do the work that I do, so I have to keep on going.
So, Dean, in your 25 years, what have you seen a story that has really just blown your mind away?
Well, I've had two, obviously, that again, no mystery. I had a client who claimed he was falsely accused of domestic violence, even though he ranked number 3 or 4 in the state of Nevada for Mr. Nevada. His wife was about 5'2", 110, and he was about 5'11", 220. But the point was he murdered his wife, shot his judge. A lot of people talk about hurting their judge. This guy actually did it. He shot his judge with a 223 Bushmaster rifle from a parking lot into the judge's chambers. He was in the hospital. The wife died, judge lived, but of course he's in prison in Nevada, has been for 20 years. This was back in 2005, 2006. And so I had a client who was a perpetrator of homicide, another client who was a victim of homicide. This case was out of North Dakota, where the wife absconded with his 2 kids to Idaho. He was falsely accused of marital rape, sexual abuse of both of his children, son and daughter, domestic violence, uh, basically from A to Z. And I testified in that case by Zoom. It was the first COVID year, 2020. We won the case. We absolved him of all allegations. He finally got a court order several months later to see his kids. He hadn't seen them or communicated with them in 3 years. When he did finally go to see them on February 5th, 2021, instead of meeting the kids, he met a 9mm Glock pistol held by the maternal grandfather, who fired 3 shots when John, my client, got out of the car, and he was killed in cold blood right there in real time. So these are horrific stories that have the potential to end in horrific tragedies if they're not handled correctly, which is
Well,
why it is so essential that an expert, whether it's myself or a psychologist or psychiatrist, work in concert very closely with counsel, the attorneys in the case.
it, it, Dean, why do you feel that there's so much allegations against fathers?
Well, so hearsay by rule, Liz, is an out of court statement made for the truth of the matter asserted. Generally speaking, it's legally inadmissible. Not so here. When a child makes an outcry of physical or sexual abuse, when a medical provider is told, a therapist, doctor, nurse, that a child has been molested, for example, they are mandated reporters. They have to call it in. This becomes what's called an exception to the hearsay rule. So we don't usually see forensic medical findings in these cases. Perhaps 5% of the time, 1 in 20, will we see actual medical findings. Most of these cases are he said, she said, what a child said. And that's all that's necessary for the proof to send somebody in my state of Florida, for example, to life in prison without the possibility of parole.
Wow. Dean, in your work, how many times have you seen the court system fail the fathers?
Well, they failed both genders. So my practice is obviously gender neutral. I get a lot of women who have been wrongly accused of failure to protect, coaching their kid to falsely accuse the father or stepfather of sexual assault, Munchausen by proxy, another psychological medical disorder. Uh, Coaching, as I said, losing custody, right? Usually when sexual abuse, that's the father or the uncle or the stepfather who's the one wrongly accused. So I would say in sexual child abuse cases, it's about 95% to 5% male to female. In those cases, however, the mother she can be served papers by Child Protective Services for failure to protect, that she was actually complicit with the sexual abuse of the kid. So there's another issue. Mother can be dragged into juvenile court and eventually lose her parental rights.
Wow. We have a question here from Jonathan, and it is, what advice would you give families feeling overwhelmed by complicated legal situations?
Well, I'm not a guy that gives up, so I don't advise my clients to do that. Of course, I'm just the running back. The attorney is the quarterback and controls the litigation. So, I mean, look, I just changed my website for 30 years. I own the Abuse Excuse website, abuse-excuse.com. That has been changed to expertdeantong.com. So the point there is. There was a section at the website, there is at the new website, how to choose your attorney. There really is an art and science to picking the right lawyer. You can't be throwing darts at the dartboard here. It's not just what you know, it's who you know. So you have to have the right lawyer on board, making sure that that lawyer has not only experience, but a successful track record in litigating or trying the type of case you're involved in, whether it's family court, juvenile court, criminal court, administrative court, where CPS can place your name on the child abuse registry. But you're not going to hear it from me to just give up because you're out of money or you don't want to choose another lawyer. You're done. You got to think of your kids. You got to put the needs of the kids ahead of your own needs.
So, Dean, can we talk about protecting children's well-beings?
Can we talk about that?
Yeah, can we talk about some of the things that we can see in the courts for protecting children's well-beings? Like, are there certain orders? Are there certain yeah, court orders
Well,
that are being
so
done?
well, the court assimilates and obtains the evidence, Liz, from the attorneys, from the experts that they appoint, whether it's a child custody evaluator or guardian ad litem, which is an attorney, usually from a parenting coordinator. We see that person oftentimes in high conflict parental alienation cases where there's psychological, mental, emotional child abuse. Perhaps a social investigator or a therapist is appointed as well uh, for reunification therapy or what we call therapeutic visitation. So the court, just like the attorneys, they're well-meaning, well-intentioned, but they're not psychiatrists or psychologists or neurologists. They have little education and training in science, right? So they need help in the mental health field, psychology, behavioral science, social science. Child Protective Services, you're talking social science. So you're getting a conglomeration of fields here, and they're all converging. And so, my job is to help intersect the facts of the case with the alleged facts, with the science and the law. And usually, in my caseload over the last over 30 years, if those four dots are connected in court, you will prevail.
Dean, we have a question here from Jeffrey, and it has technology changed the way investigations are handled?
Well, I'm not an investigator, Jeffrey. So my job is to review and critique everybody involved in the case, whether it's the Child Protective Services, the Child Protection Team who does the medical rape examination, and the child forensic interview therapists. That's my job. Whether CPS and the police are using AI or Chat GPT as technology to better what they're doing to make their jobs easier, I have no clue. But we do require evidence-based best practices. There is a case law that governs the admissibility of science and expert testimony in court. That case law is typically known as Daubert and Fry. Most states adhere to Daubert, which is Rule 702, which basically says that the science or expert testimony must be peer reviewed, must be published, must have a known error rate, must be generally accepted into the scientific field, and must be peer reviewed. So there are factors with Daubert that are more stringent than Fry. Fry is the easier test for experts to testify. For example, I testified in Pennsylvania last November 2025. Pennsylvania still adheres to the old Fry standard.
This is the first time I'm hearing about the fry. Could you tell my listeners a little bit more about the fry?
Fry is a 1923 case, uh, United States versus Fry, and basically back then, which is more than 100 years ago, uh, judges only required the expert to ensure that the scientific testimony, the expert testimony, was generally accepted by the entire medical or scientific or psychological community. Now we have to have peer review, we have to have reliability and validity. The test that you're or the theory that you're talking about has to be scientifically tested and replicated. Okay, so it's much more. There are many more standards under Daubert than Fry that have to be adhered to for a court to accept that type of testimony.
And Dean, are they doing more investigations with medical examinations in today from 40 years ago when you were falsely accused?
I don't think so. They're still doing, for example, your typical anogenital rape exam will include a direct visual examination by what's now called the APRN, Advanced Practical Registered Nurse, or the SANE, SANE, which is a sexual abuse nurse examiner, or the physician if there's a DO or MD there. So they do that. There's usually three prongs to that test. There's a direct visual examination. There's what's called Woods light, and then there's the colposcopic examination, which is the device called a colposcope, which has a 35 millimeter camera attached to the same, which can take color photographs of the genital area. Those photographs can be used by the defense to retain their own critiquing or impeaching forensic pediatrician against the state's doctor or nurse.
And Dean, can we talk about the damage that false allegations cause families and children?
Yeah, that's very telling, and we talk about that in our new book, Parents Pawns, which was just released last week. There's a whole chapter on that, a couple chapters actually, and it's very significant, Liz, because we see psychosomatic issues, we see the same stomach aches and headaches and nausea and vomiting issues that we see in kids who've been sexually abused or raped as a non-abused child who's treated as if she has been abused but actually has not. Uh, these cases of misinformation or false allegations can wind up with that same child later in life suffering long-term false memories.
Can we talk about that a little bit? Because that's the first time I'm hearing that too, is the false term memories.
Yeah, so there's a renowned psychologist who has been my associate for decades, back to the 90s. Dr. Elizabeth Loftus is still present on LinkedIn, arguably the leading expert in the world on human memory. And so she co-authored a study published in 2011 that basically uh, found through the studies with her colleagues that misinformation that is detected early on in a case where what she studied back in 1975 called the misinformation effect, if that is activated early on in a case and CPS, the police, the child forensic interviewer don't know about that, um, and it turns out that the case is unsubstantiated, but the child goes through multiple investigations and interviews, or it is substantiated erroneously, that same child can suffer long-term false memories as a later teen into her adult years.
And Dean, is there any uh, criminal charges being brought to these parents that are doing these false allegations?
Not much, Liz. In my state, I was instrumental about 28 years ago in the late 90s. I helped Florida legislature pass what became known as the malicious false allegation statute 39.205 subsection 9, where in my state of Florida you could go to prison if you maliciously in bad faith falsely accuse somebody of child abuse, but you got to prove it. It's not what you know, it's what you can prove. So in order to prove somebody maliciously did that, well, that's going to take quite an investigation without the person who falsely accused admitting to the same. uh, I don't find many prosecutions, even in states like mine, that hold it to be a felony, where somebody could go to prison for up to 5 years. because the police think that, well, if we arrest a woman who falsely accuses a man, that's going to send a chilling effect to future children and women. And it's going to make them tight-lipped. They're not going to want to report because they're going to think, gee, if I report, this turns out to be a witch hunt or a fishing expedition, I'm going to wind up getting arrested when I'm reporting in good faith, not bad faith. So police don't really like to put people in handcuffs for making false allegations.
Wow. That's something that needs to be changed because going around and just accusing people of stuff is it's wrong because there are people that have gone through these situations where they are true and the court systems are turning a blind eye when the facts are true, because there's so much false allegations coming to the table.
Yeah, it is true that judges, when judges who have been on the bench for a while, and they see dozens of cases, right? When they see anecdotal evidence within their own caseload that, oh, well, this is a custody battle, this is a protracted divorce, up, she just filed child sex abuse charges, up, CPS and the police unfounded that they didn't find any proof. Ma'am, I'm going to have to take the kid away from you. I just can't. The timing is written on the wall that you wrongly accused this guy. So, we can't have knee-jerk reactions here, right?
Yeah,
We have to have a we have to have like a multidisciplinary team, which is what the system uses, right? Within the courtroom, and all minds are put together in the best interest of the children. We just can't have this knee-jerk reaction and remove kids from families based on, oh, well, you know, um, he allegedly shook that little baby. She's having a subdural hematoma and retinal hemorrhages. It must be shaken baby syndrome when it could be Ehlers-Danlos or rickets, vitamin D deficiency, or osteogenesis imperfecta, right? Some congenital disease. So we have to consider alternative hypotheses. It's essential. There might be another reason what's going on here. That's why we have to do a very objective, independent, neutral investigation that includes a lot of collateral interviews.
absolutely. And we need to really focus on real evidence, not just word of mouth, right?
Well, yeah. So again, as I explained, hearsay exceptions to the rule will allow the hearsay in, but then the judge has to make a determination on the reliability and trustworthiness of that hearsay.
So, Dean, I want to talk to you about because I have a son, and I've said this many times to all of my listeners and to anybody that knows me. I want my son to have the same rights as women have. I don't want just women having rights. I want males to have rights too, and fathers have rights too. How can we change that? Because the courts automatically go to the mom's side a lot, and I'm a mom as well, and I want my son to be able to have the same rights as what I have as a mother, as a father.
Yeah, I wish I had an answer for that one, Liz. Unfortunately, I don't because gender misandry and misogyny that's been going on for decades pretty runs the gamut here. And so, when you get true believers, when you get child savers who go by hearsay and then they start marching outside of Washington, D.C., and then almost 10 years ago, you pass what became known as the Me Too movement. You get a lot of well-meaning, well-intentioned, but perhaps misguided people champion a cause which may be rife with ideology and not science and fact, and people are going to get falsely accused, right? People are going to get wrongly accused. Those are usually men in those situations, not the women. So I don't like to take a gender partisan side here because moms reach out to me when they need my services and my help, and I'm hoping that we can lay down our arms and if you will, the gender anti-Semitism that goes along with this. We don't need that. It's not good for anyone. We need to go by facts and science.
Absolutely, 100%. And I'm really happy that you work with women, not just fathers, mothers as well. Thank you for that, Dean. Uh, how do we break the stigma on fathers? Like, because There's so many people that say, oh, he's a deadbeat. Oh, he's a bad father. Oh, he's this, he's that. How can we change that stigma by having this conversation today?
Yeah, that's another conundrum that I don't know that I can answer that one successfully, or the way your audience will appreciate my answer, because again, been going on for a long time. Um, when you're accused of child sex abuse or something in a heated divorce and custody battle, this becomes known as divorce's atomic bomb, the ultimate weapon, where a child can be wielded as a pawn weapon or tool, as ammunition, as a messenger, if you will, to uh, to cause one party to gain more equity at law and court than the other party. Uh, on the stigma, uh, it becomes a mother's rights, father's rights deal. There are guys out there who don't pay their child support, who abandon their kids. And unfortunately, those guys cause this, if you will, pervasive, ubiquitous stigma that unfortunately attaches to the good parent, the good father, who's always paid his support, who's always exercised his visitation rights, and unfortunately he gets cast and thrown with a stone and lumped into that same mold, and that's not fair.
Yeah. It really isn't. Let's talk about some of the services that you offer, Dean. I found consulting expert, testifying expert, and limited scope. Could you tell me a little bit about each of those services?
Sure. So, as a consultant, which is usually how I get involved in a case, Liz, and I think the first thing people get concerned with an expert is, oh my God, he must be so expensive and more expensive than the attorneys, and there's no way I could afford this guy. Well, so if you're in criminal court or juvenile court, I just want to say, if you're fighting for your freedom, if you're fighting for your parental rights, and you don't have the resources, and the judge finds you what's called informa pauperis or indigent, basically that you're on the poverty level there, you can get my services, you can get my work and my time at no cost to you or your family. The judge would have to order the state to pay my fees. And that's happened in a dozen states, okay, in many cases. I've got three right now that I'm working where the state is paying for my work and my time. Um, rather family court, unfortunately, you get as much justice as you can afford, and that's the way it is in America. So if you don't have the pocketbook and you go into family court, as it's called in my state of Florida, time sharing or visitation or custody, Houston, you're going to have a problem. It's just the way it is, and it's unfortunate. And trust me, I've tried for decades to try to get the family court to use the same methodology that juvenile and criminal court uses for people who don't have the resources for these long, protracted custody fights that can really last years. And the legislature just hasn't listened. They just won't listen. But as a consultant, I work with the attorney on strategy, on theory, uh, basically helping the lawyer with questions for depositions, questions for impeachment of opposing fact and expert witnesses. As an expert witness, of course, I testify in multiple areas of psychology and social science, including cognitive developmental child psychology, including evidence-based best practices for child forensic interviews, including risk assessment, psychosexual testing. So a lot of my clients will actually have to prove a negative and their innocence, that they're not the monster that the state is painting them to be by going through a battery test that shows they don't possess any sexual interest or propensity to hurt a child. Um, uh, there are other areas of psychology that I testify to, and of course, perhaps the largest area is the proper handling versus mishandling of the child protective investigation by the police, by child protective services. A lot of times they will rush to judgment. They will exhibit what we call confirmation bias. They will not conduct source monitoring. They have this belief that, well, if the kid said it, uh, it must be true. The child wouldn't lie. And therefore, our job is to protect the kid, not you, the accused. You're walking away in handcuffs. Um, and then, of course, limited scope is basically my work just centering around the child's forensic interview, which could be aged 3 to 17. in this country. I've worked in work cases from all 50 states. I've testified in 20 of the 50 states.
Wow. Uh, Dean, let's talk about some of these books that you've written. Let's start off with Don't Blame Me, Daddy first. I can't pull the books up
Yeah,
because we're in Zoom, but I will put all the information in the description of this podcast, this episode, so people can find all these books as well, because I believe they're all available on Amazon, correct?
correct. Yeah, they all are now. And you'll have to forgive me because while one of the areas of expertise I testify in is memory, Don't Blame Me, Daddy goes back about 35 years. Um, and the book was written basically because I myself had gone through my own trials and tribulations in Florida. I got some other guys to tag along, if you will. So the early chapters of that book are other men's stories besides my own. And then I take the reader through basically, the breakdown of a case, the accused, the accuser, the child victim, the agencies that you're going to run into in an investigation, the hoops you're going to have to jump through when you meet up with Child Protective Services in a court case. Um, I take the reader through parental alienation a little bit, and also the medical anogenital rape examination rather, where oftentimes we find the nurse examiner or physician testifying that the exam was WNL, meaning within normal limits, but the child's history is consistent, where it does not rule out child sexual abuse and neither confirms nor negates child sexual abuse. So the nurse or the doctor is leaving it on that 50-yard line in that gray area, again, to err on the side of caution, on the side of the kid. So it almost requires the defense lawyer to hire a trauma forensic pediatrician to testify against that nurse or doctor. And
Wow.
usually, yeah, we lose findings, medical findings, very quickly in these rape exams. So if they're not done within 3 days of the day of the outcry, it's almost a waste of time and effort and money to do that. Oftentimes, I'll get a case, and the exam might be done a year, 2 years after the outcry, which is you're not gonna see anything but scarring upon medical examination. So that's what that book goes into. And of course, I was a little bit fortunate with the timing of that book because Woody Allen, the actor Woody Allen, was going through his situation the same year. That book was published in 1992 with Mia Farrow in the state of Connecticut. Uh, that book, by the way, was the first book to hit the old bookstores that we don't have anymore, B. Dalton's, Walden Books, and Borders. Uh, so it basically was the, if you will, inroad book on this issue to the bookstores that was accepted by the bookstores on this issue, and for that I was thankful and humbled by that. The next book I self-published. That first book, by the way, was published by Hampton Roads, which is the same publishing company that published the book Conversations with God, which I believe became a bestseller. That book. The next book I self-published, Ashes to Ashes, Families to Dust. Basically, the '90s I spent more as an activist or advocate. The mid '90s, early '90s, trying to get the laws changed, trying to bring awareness and visibility to this issue. Uh, and I became a thorn in the side of the government because I did so many interviews with the media as I'm doing with you right now. I just became a nonstop Energizer bunny, and was relentless in my pursuit of rectifying this issue. Then I took it to another level. So in 2000, I decided it was time to get further education. I started in to go into my master's program, I went 6 years, right? Because I was going part time. So instead of your normal 2 to 4 year program, this took me 6 years. I didn't get my degree until 2006. But during that interim time frame, I published my third book, Elusive Innocence, in 2002. And that book, there are chapters on the iatrogenic or harmful effects to the child victim, to the accused parent who's wrongly accused, Borderline personality disorder, we find is a very common disorder, especially in women. I guess I'm not trying to be gender biased here, but it's a fact. A lot of these women have been seen at McLean Hospital in Belmont, Massachusetts. That's a state I was born and raised in. And Dr. Gunderson actually is one of the psychiatrists or psychologists over there. And he developed what's called the DIBR test, the Diagnostic Interview for Borderline's Revised Test, which is one of the seminal tests in this field. So borderline personality disorder, very common uh, cluster disorder where a parent basically has an extreme fear of separation from her children, and she doesn't see gray. She sees things as black or white, basically her way or the highway. That type of parent could be described as a helicopter parent, hovering over her kids, where she's gaining 100% enmeshment. The targeted or accused parent will lose emotional attachment to those kids, and the parent and the child lose ambivalence. They basically lose any mixed feelings. Basically feel righteous in what they're doing, that it's for the better good to estrange the child or children from the targeted accused parent. So the child goes through phases. What Dr. William Burnett, who's an associate of mine, psychiatrist out of Tennessee, did a lot of studies on this and published books on this issue, where now the classification of parentalation is now mild, moderate, and severe. It used to be slight, moderate, and severe. Now it's mild, moderate, and severe. When we get to the severe stage of alienation, that's when the child is rejecting the targeted parent, the accused parent. And at that stage, it's very hard to accomplish a reunification between the falsely accused and the child. And the courts are at a loss. They basically will order reunification therapy, thinking that the therapist has some bright light bulb idea that whatever she does is going to fix this. And usually, with all due respect to the therapists out there, it does not fix this.
Yeah.
So there is a form of therapy called schema, SCHEMA therapy. Schemas are enzymes or proteins that can cause an alteration of one's memory, and they have an actual therapy. If you Google it, you'll get a Wikipedia page on it called schema therapy. It has to be a certified schema therapist, and if that's a working, functioning model, it can help basically reprogram the child's memory to go back in the child's mind to the way it used to be, the normal relationship that the falsely accused parent had with that kid before the false allegations were leveled and causing an estrangement between targeted parent and the child victim. So there are not too many models of therapy that are successful. That is one, schema therapy. Cognitive processing therapy is another one. So that's basically the essence of elusive innocence. There's also a chapter on false allegations of domestic violence, not just child abuse, but domestic violence in he said, she said type cases. And then coming up to 2026, right? So almost a quarter century lap there for me between publishing my third and fourth books. This one is co-authored with a clinical forensic psychologist, Dr. Alan Blotsky, an expert in parental alienation. He's also the editor of the journal that comes out, the newsletter from the PASG, which is the Parental Alienation Study Group. The website for that for you folks is pasg.info. pasg.info. Very, very informative website on what's up to date, what's going on with parental alienation. And this is around the globe. This is around the world, not just here in the USA. So the parents' pawns, wow, we tackle the ABCs of parental alienation, risk assessment, child hearsay, the harmful effects to alienation to the child, especially, but also the falsely accused parent. We talk about false allegations, of course, which is more my cup of tea. To excuse the pun for this show,
I love
but
it.
Dr. Blotsky is much more the expert in parental alienation.
So all these books can be found on Amazon, correct?
Yes, they just put up Parents Pawns a couple of days ago at Amazon, correct.
And what do you want people to get from those books, Dean?
Just to understand there's another side to this divisive coin, right? And to understand that it's going to take a lot of work and effort. You got to roll your sleeves up to be able to be able to defeat big government, Uncle Sam in these cases, right? When CPS, the police, Child Protection Team, the CAC, Child Advocacy Center, all get together. Let me tell you, it can be a nightmare and a very quick one. So don't be too quick to pull your trigger on that $25,000 retainer to that lawyer who's got great Avo reviews, who's board certified in family law. You better do more vetting than that. Figure out how many cases that lawyer has tried, how many successful cases that lawyer has won, because you're not going to get that lawyer's real references. You'll get no names or phone numbers to people you can call that lawyer has represented in the past.
Well, Dean, we have a question here for you, and it is, are there new projects or books you're currently working on?
I just finished up this fourth one, trying to catch my breath. And I operate a very busy caseload. There are very few people in this country that do the work that I do. So you have to understand this issue never stops. The peer-reviewed articles never stop. It's a very dynamic field, whether it's psychosexual risk assessment, whether it's therapy, whether it's a new model that comes out in child forensic interviewing. Um, it just never stops. And so there's a lot of, I'm an old man now. I'm turning 70 years old, and it's hard to keep up with the amount of information that comes in on this issue at this age versus when I started out in this field when I was in my 20s and 30s.
Well, we have another question for you, Nadine, and it is, what advice would you give someone beginning a career in forensic consulting?
Uh, well, you need a background in criminal justice as well as psychology and preferably social science. So I believe there's a program out of Virginia. Obviously, my degree was specifically psychology and law in the specific field of child forensic studies. I don't know that program that I just mentioned is offered here in the USA, but with all the online universities we have now, Phoenix and Walden, and um, the folks should be able to go online and see what universities, what colleges are offering a program, a master's degree, because you will need a master's, and to be able to help a lawyer. Your job is to assist the attorney. That's your job. Your job is to assist the attorney to help the falsely accused uh, clear their name. On the same side, your job is to help the attorney to uh, basically get to the truth of the matter, right? I have cases where real abuse has happened. I just had to get done with the case here in Florida, and I actually had to testify in part against my own client because they used some suggestive leading and direct questions when they asked the kid questions, right? I had to testify that I can't lie. So uh, you have to be very careful in this field. You're not getting cherry picked information from the attorneys. You have to ask questions. Lawyers are notorious for possibly glossing over uh, some contextual details and facts. So I'm looking for errors of commission, errors of omission, what the lawyer might have done wrong, what they might have missed. But you'll need anybody who has an endeavor to get into this work understand. It's a lot of work. It's very painstaking. It's very grievous. It can be traumatic because you're going to see some real abuse, and you're going to see false allegations, and you're going to see people take plea bargains that maybe they shouldn't have. They should have gone to trial, but the lawyer said, no, we're taking a plea agreement. It's not up to you as a forensic consultant or the expert. That's up to the lawyer. You're going to see justice go basically get thrown out the window in cases that you can't believe the way the case turned out. So it's going to be depressing at times.
Dean, being falsely accused for sexual assault on your children and then working in this field and seeing that there are some guilty fathers out there, how does that affect you?
Well, I've always known that there were two sides to this coin, Liz, and I guess it's why I'm so diligent in getting my clients tested so that I know to a degree of certainty that they're squeaky clean. Before this goes to a trial, I have empirical data, raw test data that shows my guy doesn't show sexual interest to children. His cognitive distortion scale score is low, so he doesn't suffer from thinking errors. He's not trying to justify himself. There are no justifications. He's not trying to be a con man or hoodwink anybody. He's being honest to a fault. That's what I want to see in my doc's report. And for those out there, if you don't know, I have a PhD who I've been working cases with for 20 years, who does all my testing of my clients for me.
Dean, what are some common misconceptions surrounding high conflict custody cases?
Well, I think the number one misconception is that women get custody 85% of the time. I mean, that certainly doesn't hold true in my caseload. If it did, I probably would be somewhat out of business. So I get a good portion of the fathers who hire me wind up on the side where they are a primary responsibility, a primary residential parent, I should say, and they actually win. So that's one misconception. Uh, I think another one is the amount of money you're going to spend. You might get a lawyer to tell you, "Oh, you're going to spend 100,000 or 200,000. This is going to last for years. It's not going to stop." Well, look, lawyers are trained in law school on billable hours, right? They're trained tabulate and ring up billable hours. Don't let that happen. Don't let the lawyer play the let's wait and see what happens game. I'm from Boston. I like to work at a very aggressive pace in a case because the work never stops. The cases never stop. Right now, there may be a child at a child advocacy center in Scranton, Pennsylvania, going through a forensic interview right now as we're speaking, because she made an outcry an hour ago. So it's a 24/7, 365 field that never stops, and unfortunately, there is a monetary factor with this industry, if you will. The government gets a kickback from the federal government. It goes all the way back to the Child Abuse Prevention and Treatment Act, known as CAPTA, 1974, to the Social Security Act titles that came in the 90s. And you had the VAWA, the Violence Against Women Act, in 1994. That was our former President Joe Biden, who was a senator at the time, and he got President Clinton to sign that into law. And then, of course, we had Clinton himself with his wife sign ASFA, the Adoption and Safe Families Act, in 1997. So all these laws were basically well-meaning to protect the children, but they forgot one thing when they enacted these laws. They forgot the essence of the family, of the American family.
Well, that's it, right? It's destroying families. It's not just destroying parents, it's destroying the family because the whole family is affected when there's false allegations going on.
Well, sure, and grandparents and uncles and aunts and step parents and et cetera, et cetera. So yeah, it is, and that's exactly why the attorney should be asking for help when the attorney doesn't knows that there's an issue on the table that he or she can't handle. They have to reach out for help because they usually do need help when governmental agencies are involved.
Absolutely. How can professionals better recognize the effects of parental alienation, Dean?
Experts, you were saying?
How can professionals better recognize the effects of parental alienation?
So I'm a real stickler on obtaining the parenting app messages, Liz, between the litigants. So that would be Our Family Wizard or Talking Parents or what's called app close. You've got to see those messages. You've got to see the text messages. You've got to see the social media posts. You have to ascertain if there's denigration, vilification, disparaging by one parent against the other parent, especially in the presence of the child or children, because that is the essence of child psychological abuse. The thing with alienation is the first sign of alienation is the altering of the mind or the belief system of the child. Once you can modify the mind and belief system of the child will alter his or her narrative. And then you have a problem. Once that narrative is disclosed to a mandated reporter, the government gets involved. And then if the child implicates you during the forensic interview, which is basically the smoking gun in these hearsay cases, now you're in my world.
What is said and why is it and why is understanding it important? SAID. What is that?
Yeah, so that's the 911, Liz, of parental alienation. Sexual allegations and divorce was a theory authored and developed by psychologist Blush and Ross out of Sterling Heights, Michigan, back in 1987, almost 40 years ago. And basically, I did some work that overlapped their work. So I've been known to be an expert on SAID. A couple of experts out of Canada, Trockme and Bala, have done some work on that, as well as Dr. McKay out of the United Kingdom. So basically, SAID comes into play. We have usually a preschool child, a child who is making an outcry, but the child appears rehearsed or scripted or mechanical. In other words, she appears coached. Appears coached. These are the kids that can talk about the Tooth Fairy, Santa Claus, Peter Pan, the Easter Bunny. Can talk about how daddy or stepdaddy touched my pee-pee. And so these kids can easily be influenced to say things that never happened. A lot of studies were done on this back in the 90s. Dr. Stephen Ceci and his colleague, Dr. Maggie Bruck, they published a book in 95 called The Jeopardy in the Courtroom, which became a bestseller published by the American Psychological Association. So very important said. A lot of people on Facebook and social media refer to it as the silver bullet. The problem with the silver bullet is there's no scientific evidence there is a silver bullet in this field. The scientific evidence lends itself to SAID, SAID, sexual allegations in divorce, is what that acronym stands for. There is no scientific evidence to the theory of the silver bullet.
Dean, what changes would you like to see within the family court systems?
Well, I think that starts with legislative changes, Liz, and I already mentioned one, the Child Abuse Prevention and Treatment Act of 74. I think needs to be abrogated or repealed. I think it needs to be modified to include, like you said, criminal penalties against false accusers. We need to take a better look at the harmful effects of false accusations or unsubstantiated allegations against parents, child victims of the same, cases that don't preponderate or meet 51%. That's a very slippery slope in family court. I think the legislature should hurdle back the discretion of family court judges. They have too much discretion to ruin your life in a New York minute. So I think that needs to be looked at. I think we need to mandate a team of professionals in these cases. And I understand the system doesn't want to spend more money, but I mean, there's no choice. You've got to spend the money. You've got to protect our most precious resource, our kids, and to do that, you're going to have to spend the resources and conglomerate a team, forensic team that can get to the bottom line. Did this happen? Did this not happen? If it did happen, prosecute the perpetrator to the fullest extent allowed by law. If it didn't happen, if we're not going to punish the, if you will, false accuser, if this is a mistake, by professionals who just didn't do their job properly, well, you're opening yourself up to civil lawsuits then.
Yeah, absolutely. So, Dean, what final message would you have for the listeners tonight? And where can people reach out to you to have you as a guest on that as well?
Well, I think the message, Liz, is that especially with July 4th coming up in our 250th anniversary, that in these cases where you can be jailed perhaps for the rest of your life, convicted of a felony, required to register as a sex offender for something you never did, um, that there's a level of due process that has to be ensured and allowed for the accused. That's the right to counsel and experts. That's the first thing. Um, as far as contacting me, I would urge people to go through my new website, www.expertdeantong.com.
Well, thank you so much, Dean. I really appreciated this conversation with you and bringing this topic to the table because this one was a trigger warning for myself. But I believe that there are good fathers out there. Some of us are not blessed with good fathers, but there are good fathers out there. So thank you, Dean, for bringing this to the table, and thank you for writing those books and bringing the awareness. One last question, Dean, before we wrap up: are any of your books used in court cases?
Yes, they have come in. Certainly, this one just published will definitely come in as what's called a learned treatise in court for attorneys to introduce into evidence onto a court record. Usually, though, it has to come through the expert's opinion. It doesn't have to be the author or co-author of the book. It could be another psychologist or psychiatrist or neurologist, whomever. But a academic book for sure can come in as a learned treatise. My other books are not academic books. This one is.
But thank you so much. I really appreciate you reaching out and wanting to be on Tea Time and getting this out there. We're just going to do a quick recap of what Tea Time is, and uh, we'll be seeing everybody on Tuesday and Thursday, and we'll do this all over again, guys. What an important and thoughtful, provoking conversation we've shared tonight. Dean, thank you for bringing your experience, knowledge, and perspective to the Tea Time table. Conversations like this are never simple, but they are necessary when they encourage thoughtful dialogue about protecting children and supporting families through difficult situations. Tonight, we discussed child safety, child family, high conflict custody cases, the roles of evidence, and the importance of ensuring that every child grows up in a safe, healthy, and supportive environment. One of the strongest takeaways from tonight's tea time and conversation is this: children should never become the casualties of adult conflict. Whether we are parents, grandparents, professionals, educators, or community members, we all share a responsibility to advocate for children's safety, emotional well-being, and healthy relationships within possible. Tonight's discussion also reminded us that complex family situations deserve careful listening through investigation and decision rooted in facts, compassion, and the best interests of the child. As we close tonight's tea time, I leave everyone with this thought: how can each of us help create a world where every child feels safe, loved, heard, and protected? Because when we place children at the heart of every decision, we create stronger families, healthier communities, and a brighter future for everyone. Thank you, Dean, for joining us and contributing to this important conversation. Until next time, continue listening with compassion, seeking understanding, and serving real life tea, one conversation at a time. And tonight's takeaway is every child deserves safety, stability, and the opportunity to maintain healthy relationships whenever it is safe and appropriate to do so. Honest conversations, careful evidence, and compassion helps us work towards that goal. Thank you, everybody, for joining me on Tea Time. It was a pleasure having you, Dean.
Thank you for having me.